Good morning, everyone, or afternoon or evening, depending on where you are. We're very thankful for you to joining us today to discuss the challenges of regulating the use of armed drones. Apologies for the slight delay. As many of you might know, we were trying and still are trying to get Yemen on the line, so I'm hopeful that'll happen by the Q&A. In the meantime, my name is Jennifer Gibson, and I work for Reprieve, an international NGO that provides free legal and investigative support to some of the world's most vulnerable people, including those victimized by states' abusive counterterrorism practices. For over a decade, we've worked closely with civilian victims of drone strikes, investigating their cases and trying to secure accountability. We're delighted today to be co-hosting the event with the government of Pakistan and the peace organization PAX. Before we get started, and as is typical in this kind of new remote environment that's not so new anymore, I'm going to run through a bit of housekeeping. Everyone's microphones have been muted except the panelists, and the panelists themselves will have their microphones muted unless they're speaking. Cameras have also been switched off by the host during the presentations. For interpretation, there is simultaneous interpretation of this event. We will be interpreting into Arabic and back out of Arabic for our colleagues who've been able to join us from Arabic-speaking countries. Please, in the interpretation button, which you should all have at the bottom, select English or Arabic. This will ensure that those who are speaking in Arabic get translated to English for our English speakers, and alternatively, if you want to listen in Arabic, that the English is being translated into Arabic. Please also select mute original audio so that you only hear the translator. If you're having any difficulties on this front, then unmute the original audio and try that, but it should work best by muting the original audio. You may submit questions for the panelists during the meeting. To do so, please submit your name, organization, and question via the Q&A function in the Zoom panel. Please also note, if you want to make an oral statement, we know several states parties are joining us, please do indicate by Q&A, and we have the ability to allow you to make an oral statement. Feel free, as always, to live tweet. We're suggesting the hashtag HRC48 #drones, but we hope you will enjoy the event. And if you run into any problems, the chat box is turned off, but please do let us know via the Q&A. This slide explains what I've just explained in Arabic for those joining us who need it in Arabic. I'm just going to give 1 minute for people to absorb what's on there, and then we'll move on. Okay. I'm going to turn it over now just to our partner PAX, who's co-hosting, to make a couple of brief comments.
Yes, thank you very much, Jen. Hello, everyone. My name is Alejandra Munoz, and I'm a project officer at Dutch peace organization PAX. And PAX works on humanitarian disarmament and engaged in peace building. Also, on behalf of PAX, we would like to welcome everyone joining this webinar today. We're glad to see you're all here, which only shows the interest and urgency surrounding this topic of armed drone use. With today's events, we hope to stimulate greater public and political discussions on this important issue. We are very pleased to be co-hosting this event with Reprieve, and would also like to thank the government of Pakistan for kindly agreeing to sponsor this event. And of course, would like to thank all panelists for their participation in today's conversation. In spite of repeated concerns voiced over the years by states, lawyers, journalists, affected communities, UN experts, and civil society actors over the growing threat posed by drones, by the use of armed drones. Drones have now become the weapon of choice worldwide, with at least 30 countries currently operating armed drones or in the process of doing so. Proponents of their use have often hailed them for their unique advantages including their capability to strike a target with precision. The way this plays out in reality, however, often tells a different story. Among others, the intelligence such targeting decisions are based on can be unreliable, leading to far more civilian casualties than is often acknowledged. The recent US drone strike in Afghanistan, which killed 10 people, including 7 children, illustrates once more the devastating consequences of such deadly mistakes. Now, almost 2 decades after the first use by the US of armed drones to carry out so-called targeted killings, many nations now resort to drones as a central tool in their counterterrorism operations. In addition to ongoing concerns of transparency and accountability, the absence of effective oversight mechanisms risks further undermining international legal principles that protect the human right to life and that place stringent conditions on the use of force. At the same time, we are also witnessing now how more and more non-state armed groups are able to assemble small military drones from easily available drone technology. Meanwhile, civilians continue to suffer from the consequences of armed drone use and armed drone operations, which extend far beyond physical injuries and killings. PAX therefore wishes to encourage states to utilize fora such as the Human Rights Council to bring this issue back on the international agenda and to engage in multilateral discussions towards the development of strong international norms to regulate armed drone use. We hope that today's discussion will put the spotlight on the need for states to adopt clear, robust, and progressive positions on the use of force outside situations of armed conflict, and to stand up for human rights in the face of this growing threat of remotely controlled violence. Again, a very warm welcome, and we look forward to today's conversation.
Wonderful. Thank you, Alejandra. And just to add our thanks, welcome and thanks on behalf of Reprieve for attending today. As Alejandra said, this September marks 20 years since armed drones were first used outside of armed conflict. Over the last decade, we have seen their use increase dramatically, both on and off the battlefield and amongst both state and non-state actors. Drones, quite simply, have become the go-to weapon for counterterrorism operations. As the use of drones has increased, so too have concerns. Drones have made it easier for states to use force outside of armed conflict and more difficult to identify who has carried out a strike and who therefore should be held accountable for the harm. The way they have been used and the precedents that have been set have made it easier for newly acquired states to couch everything as counterterrorism and thereby justify their use. Just a few weeks ago, the world saw firsthand what happens when the intelligence behind a strike turns out to be wrong. The Ahmadi family had hopes of being evacuated from Afghanistan. Instead, they lost 10 members of their family, including 7 children. Yet the family was repeatedly accused of being linked to ISIS-K, even as evidence built up to the contrary. It was only after CCTV footage emerged that an apology was forthcoming. Unfortunately, the Ahmadi story is not unique. Reprieve's own investigations and those of countless others have shown time and time again that while the drone itself might be a precise weapon, the intelligence that feeds strikes is anything but. When that intelligence is, it is almost impossible for families to get answers. States fall back on claims of national security, creating an accountability vacuum. The lack of transparency and independent post-strike investigations mean communities are often met with silence when their loved ones are killed. Acknowledgement and redress are all but non-existent. This lack of redress is further compounded by the persistent presence of drones over communities. With the drone's presence comes the fear that it might strike and the inability to protect oneself if it does. Our hope is that with this event, we can start a dialogue between states, civil society, and the communities being targeted. A dialogue that starts to unpack the lessons learned over 2 decades of drone use in a way that helps us figure out where to go from here. Without further delay then, I'm delighted to interview the first of our speakers, His Excellency, Mr. Shahzad Akbar. Mr. Akbar is the advisor to the Prime Minister of Pakistan on accountability and the interior. He is also a distinguished human rights lawyer in his own right. In 2011, he founded the human rights organization, the Foundation for Fundamental Rights in Islamabad. It was the first organization of its kind in Pakistan to take on the victims of drone strikes and try to get answers for the harm that had been done. Mr. Akbar has represented more than 100 victims and victims' families who have lost loved ones in US drone strikes. His pioneering work in Pakistani courts argued that US drone strikes violated his client's fundamental rights under the Pakistani Constitution, which helped to bring about the end of US drone strikes in the country. Outside of Pakistan, Shahzad's work led to unprecedented litigation before the UK High Court, which concerned intelligence sharing by the British intelligence with the US in order to carry out drone strikes. Mr. Akbar continues to fight for this cause, having worked with Reprieve in an ongoing case regarding allegations of war crimes at the International Criminal Court. The case challenges or asks the prosecutor to include Pakistani drone victims in any sort of inquiry into war crimes in Afghanistan. It's my pleasure to hand the floor over now to His Excellency, Mr. Shahzad Akbar. Shahzad, you're on mute.
Can you hear me now?
Yes.
All right. Thank you, Jennifer. Good morning, good afternoon, and good evening, as Swedes appears to be all over the world right now. It's been a while that I've spoken on this subject, and one reason for that is that drone strikes in Pakistan, as Jennifer pointed out, stopped back in January 2018, but there's a whole history to that, how it happened. However, recently the whole issue of drone strikes and everything around it became alive when US, as we all know, carried out its last drone strike in Afghanistan on August 29th, 2021. The news was that it hit an ISIS target carrying a bomb, and one would imagine that it's not really a tribal area of Pakistan or somewhere remote where US or allies have no presence on ground and would not fully know the local terrain. It's Kabul, right? Where US was housed literally for over 20 years, spent over $2 trillion on a war. At least they would get this one right, the last drone strikes in Afghanistan. And no surprises, we were wrong to think that. Despite spending world's resources in Kabul, supposedly knowing the place better than, now we know this very last strike was not different than the very first strike itself that was carried out, killed 10 civilians, including 7 children, from world's most expensive and bloody, are faulty at best, and you never miss its intelligence. And may I just add here, we should not be executing human beings based upon mere intelligence, because it's just intelligence. Another lesson for the world on use of lethal force via drones is that terrorism cannot be fought with weapons like drone strikes alone. It simply doesn't work. Afghanistan example is right in front of us. We have another issue with the use of drones, and that is the lack of transparency and accountability, as is the topic for today's discussion. CIA use of drone, especially in Pakistan, was most troublesome, as CIA carried out over 430 drone strikes in Pakistan, killing around 4,000 people with a large number of civilians, including women and children. The worst part of drone strikes in Pakistan is there was no transparency, as CIA never admitted its role, who it killed, and almost never admitted killing civilians. Had it not been for the tireless, brave, and sorry to say, still justiceless efforts of civilian victims of Pakistani drone strikes, the world would not have known the fallacy of CIA-led drone strikes, and CIA would have let us believe drones are killing the bad guys. Now, as we sit here today in 2021, we must learn from the past. US has withdrawn from Afghanistan, and I would say that the region as well, after 20 years of war. I leave the question like, what was the point of it all to the US electorates? But we must acknowledge there are unresolved issues of accountability and justice which must be addressed. Civilian victims must officially be acknowledged and compensated. And this, I'm not talking about the recent strike in Afghanistan where the US military had carried out that strike. I'm talking about places like Yemen and Pakistan where intelligence agencies have been carrying out drone strikes. And the other important question here is about the use of drone technology. How is it to be regulated in future? I do not believe that any state, as it was pointed out in the beginning, almost 30 states are using armed drones. I do not believe that any state is going to give up use of armed drones. However, it is important to address the use of drones in and outside conflicts. There have to be rules, and there have to be consequences for any misuse of this power. How would transparency work is a big question. Another important question is that use of drones basically means giving permission to kill on a whim. There are no ticking bomb scenarios. This is what we have learned from last 20 years of use of drones in Afghanistan or Pakistan. So the question is, how is it going to be regulated within the bounds of laws? Thank you, and I'll be saying more on the question and answers.
Thank you very much, Shazad. We appreciate all of your comments and look forward to unpacking that a little bit in the Q&A. Moving on next, I'm delighted to introduce Professor Fionnuala Ní Oileáin, the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. We're delighted that Professor Ní Oileáin could join us, especially as we know she has a very, very packed schedule today. And also delighted to welcome her legal advisor, Adriana Edmeades-Jones, who's going to fill in as Professor Ní Oileáin has to pop in and out to attend another event. So Professor Ní Oileáin is concurrently Regents Professor and Robina Professor of Law, Public Policy and Society at the University of Minnesota Law School and Professor of Law at the Queen's University, Belfast, Northern Ireland. She has previously taught or held visiting positions at Harvard Law School, Columbia Law School, Princeton University, and the Hebrew University of Jerusalem. Professor Ní Oileáin is the recipient of numerous academic awards and honors, including the Leverhulme Fellowship, British Academy Awards, Fulbright Scholarship, the Allen Prize, the Robert Schuman Scholarship, a European Commission Award, and the Lowler Fellowship. She is an elected fellow of the Royal Irish Academy. She has published extensively in the fields of emergency powers, counterterrorism and human rights, conflict regulation, transitional justice, and sex-based violence in the times of war. Her book, Law in Times of Crisis, was awarded the American Society of International Law's Preeminent Prize in 2007, a certificate of merit for creative scholarship, and her published work has been extensively recognized for its path-breaking contributions and its rigor. Professor Ní Oileáin is currently the United Nations Special Rapporteur, as I mentioned, on the protection and promotion of human rights while countering terrorism, and was just re-elected, we are delighted to say, for a second term in August 2020, so she will still be around for a while. Adriana Edmeades-Jones, Professor Ní Oileán's legal advisor, is a human rights lawyer with 10 years experience in international NGOs and as a litigator chiefly in the field of national security and human rights. Prior to joining the mandate, Adriana consulted for the UN Office of the High Commissioner on Human Rights, for the UN Office of Counterterrorism and the Counterterrorism Committee of the Security Council, and leading European NGOs. Adriana holds law degrees from the University of Sydney and Yale Law School. It's now my pleasure to hand the floor over to Professor Ní Oileáin.
morning or good evening, good night to everyone. I'm very glad to join you, particularly glad to have the opportunity to again engage in dialogue supported by the government of Pakistan. We've had a very productive and ongoing conversation about these issues for many years, so it's a real pleasure to be here. I also want to thank Reprieve and PAX for bringing this conversation together. Let me say a little bit about the sort of the view of the mandate. We're evolving views, but I want to put before you some of the thoughts that we have on the legal and human rights dimensions of this really problematic and thorny question of the legal regulation of the use of drones. As all of us know, there have been 2 high-profile fatal drone attacks this month. The targeted killing of Adnan Abu Wahid al-Sahari, the imputed leader of ISIS in the Greater Sahara in Mali by French military, and the killing of 10 civilians by the US in Kabul most recently. This use of armed drones worldwide, both within the confines of formal armed conflicts, in particular geographical locales, so there's a very clear concentration to the use of drones in certain conflicts, as well as being part of an asserted global counterterrorism response, remains a matter of substantial legal controversy and clearly and undisputably poses ongoing risks to civilians. Despite the fact that there have been attempts over the last decade to urge states to agree and adopt consistent standards on the lawful use of armed drones, there's been little concrete progress in that area. I am particularly concerned about that lack of legal consensus, that lack of legal certainty and clarity, and think that there's an urgency for states to agree these fundamental legal standards, not just in the interest of greater regulation and transparency, but to ensure that we do not continue to have the situation we have, which is essentially legal gray zones, which undermine the protection and the promotion of human rights. The mandate I hold has had a number of things to say on the use of armed drones. My predecessors issued reports to the General Assembly in 2013, to the Human Rights Council in 2014, and to the Human Rights Council again in 2017. I think it's really important for us to understand that the use of armed drones comes in a broader context of the misuse of counterterrorism, that it happens in the context of a lack of an agreed international definition on what constitutes terrorism, enabling a permissive environment which allows states to define terrorism as many things in their own eyes and gives enormous latitude to the kind of operative practices they carry out without oversight and under the protective cover of that rhetorical framing. What we see about that permissive global environment is that we've had 20 years of essential impunity on the use of these kinds of weapons and technologies, and that 20 years after 9/11, a broader reckoning is absolutely required, both on the framework as well as the rhetoric that supports and enables the use of drones. The mandate I hold carried out a fact-finding inquiry in 2013 precisely on this issue, and we made a number of findings, and I'm going to present them as the sort of the kind of position that the mandate starts from. The first is, I think, important to state is that the use of armed drones as a matter of international law is not per se unlawful, but it has to be, in order to be lawful, it has to be used in strict compliance with fundamental principles of international law. And those fundamental principles include ensuring that any technology that is capable of reducing the risk of civilian casualties in armed conflict by, in particular, placing particular kinds of obligations on military commanders. In practice, of course, the use in that way has been absent. And this is one of the challenges that we face in practice, holding states accountable. The second comment I'd like to focus is on the planning in the use of technologies. It's very clear, if we look at the jurisprudence of regional courts, that there's an obligation on states in their planning to ensure that any planning in the use of a technology which may lead to deaths or the use of lawful force has to be consistent and compliant with international human rights and humanitarian law. And the absence of that compliance is seen in the lack of transparency about the rules and the framework that govern the use of armed drones. And the third really obvious statement in a way is that because states have a duty to protect civilians in armed conflict and there's an international law principle of transparency, states are under an obligation where civilians appear or have been killed to ensure that there are prompt, independent, and impartial fact-finding inquiries that not only provide a detailed public explanation, but also have the certainty or the capacity to lead to accountability. What we see in practice is that none of these things apply, and the lack of a consensus among states, which is highly convenient for those states who continue to use these technologies, ensures that we see really enormous gaps of oversight, accountability, and ultimately protection for civilians. One of the things that I, as Special Rapporteur, am most regretful about is that despite multiple requests to states to illustrate and to identify the legal basis upon which they use their drones and operate these programs, we've seen no responses by states that fully articulate the legal basis for their use. What we have seen from some countries, including the United Kingdom and the United States, is some formal statements. But those formal statements go nowhere near the kind of legal certainty and clarity that is required by international law to ensure that the use of these technologies is in compliance. So what are the key priorities? I think the first priority is that we need urgently international clarification on the basis for the basis of the use of these technologies. And that clarification has to be based on existing international law standards, specifically international human rights and humanitarian law. I would underscore in this regard the comments made by His Excellency around the lack of legal clarity around these new technologies in counterterrorism and the urgency that we need around these technologies. The second thing we need urgently is we need to address the impunity that exists for previous use. That is to say that we have seen over the last 2 decades sustained use of these technologies and the absolute dearth of accountability, leaving families and the victims in their wake with literally no adequate or meaningful response to the abrogation of their human rights. We need justice, and what justice means is we need advancing accountability at the national level for those who have been harmed, but also a clearer framework of international accountability that derives from a clear legal basis for the use of these technologies. And finally, we need remedy. Families, individuals, women, girls, men, and boys who've been killed, and all of those who have been harmed, are in need of meaningful reparation and acknowledgement. And without these, we again continue to see the use of these technologies in a gray zone, which is fundamentally unacceptable to the rule of law and to the broader commitment of states to the enforcement of human rights. So let me stop there, and I look forward, and Adriana will be picking up on some questions as I jump between meetings this morning. Thank you all.
Thank you so much, Professor Nieline. Next on our speakers list, we have Ms. Jelia Sane from Doughty Street Chambers. Jelia is a specialist practitioner in international law and immigration and asylum law. A member of the Chambers Children's Rights Group, she is particularly interested in the nexus between these areas and child rights. Ms. Sane was formally engaged as a legal consultant by the Oxford Institute for Ethics, Law, and Armed Conflict on a research project conducted jointly with Save the Children regarding overcoming barriers to accountability for core international crimes against children. She is currently acting as legal advisor to the former UN Special Rapporteur on extrajudicial summary and arbitrary executions, in respect of an investigation into extraterritorial threats to the right to life of journalists, dissenters, and activists. In 2019, she was named International Law Barrister of the Year by Advocate the Bar's leading pro bono charity in Britain. Ms. Saneh is working with Reprieve on behalf of 3 families, the Al-Amri, Al-Taisi, and Al-Hubzi families, who have filed a petition at the Inter-American Commission on Human Rights. The families are pushing for a cessation of US strikes on the community in Al-Baida, the publication of a lawful policy on the use of force, and independent and transparent investigations on the 7 attacks they have sustained in the past 7 years. I now am going to turn it over to Ms. Saneh to deliver remarks with just a brief reminder to panelists that there is simultaneous translation going on. So to give time for the translator to make that translation. Thank you very much. And over to you, Jelly.
Thank you, Jennifer. So I'm going to speak about access to legal remedies for victims, particularly children, by reference to the case that Jennifer just mentioned, which we filed earlier this year before the Inter-American Commission on Human Rights. I'm going to briefly summarize the facts of that case before providing an overview of some of the legal arguments that we presented. I should start by saying that although we represent both adults and child victims in this matter, I'm going to be placing quite a bit of emphasis in my remarks today on what happened to the children. And the reason why I'm going to do this is because when it comes to accountability, including accountability for drone strikes, children are all too often eclipsed. Their experiences go unrecorded, and what is surfaced tends to be about what happened to the adults. Now, this is a rather striking omission, firstly because child victims, like any other victims, have the right to an effective remedy as a matter of law. In addition, children are particularly vulnerable in these situations because they tend to be disproportionately affected by violence. So drones, we know, affect children's right to life, to humane treatment, to health, but they can also have a knock-on effect on children's ability to access education, for instance, or their right to an adequate standard of living. And all of these violations have incredibly far-reaching and long-term consequences on their well-being and development. Therefore, there's a need for those of us who work on the pursuit of accountability, including accountability for drone strikes, to pay greater attention to the plight of child victims. So turning to the facts, as Jennifer indicated, our clients are a group of Yemeni civilians who belong to 3 families who all live in a remote mountainous region in central Yemen. The civilians in this area, including our clients, are sheep herders and cat farmers. Since 2013, they have been subjected to 7 separate, and I quote, targeted killing operations by the US, specifically 6 drone strikes and 1 ground raid executed by a group of Navy SEALs. These attacks have resulted in the unlawful killing of at least 48 civilians, including 17 children. Now, these are not, sadly, isolated incidents. They form part of a systematic and generalized practice of extrajudicial killings carried out under a state-sanctioned counterterrorism policy. These operations remain largely cloaked in secrecy and are part and parcel of a covert war conducted by the US, which lacks both transparency in its targeting process and accountability for the harm that it inflicts. Nevertheless, evidence from media sources and NGOs strongly suggests that between 300 and 460 Yemeni civilians have been unlawfully killed by US drone strikes in since 2009, including up to 74 children. At the time that we filed, and to this day, drones continue to operate in the areas in which our clients live and may strike at any moment. This means that their lives remain at great risk, which is why in our filing, we also applied for precautionary measures. So these are our facts. Now, how can families in this situation obtain justice? Well, the first point is that the US courts offer no prospects of redress, owing to a number of procedural bars in the US legal system, such as the political question doctrine, which have effectively eliminated the rights of victims of drone strikes to access judicial remedies. So that's why we instead took the case to the Inter-American Commission, alleging multiple violations of the American Declaration on the Rights and Duties of Man, which is binding on the United States as a member state of the Organization of American States. Now, those working in this field will be aware that one of the main obstacles when it comes to remedies is jurisdiction. And unlike the European Court of Human Rights, the Inter-American system takes a broad approach to jurisdiction in extraterritorial cases. So state responsibility before the Inter-American system is engaged where a victim is present in the territory of one state, but nevertheless subject to the authority and control of another. That's the test. And authority and control is broadly conceptualized as an interference with the human rights of an individual by the state, in this case, primarily the right to life. So it's that interference that provides the jurisdictional hook. Additionally, we emphasized to the Commission that insofar as targeted drone strikes imply monitoring, tracking, surveillance, and a specific decision to kill, these are all exercises of authority and control, which in our submission firmly place an individual under the jurisdiction of the targeting state. In terms of the substance of our submissions, we raised 5 principal arguments before the Commission. Firstly, we said that the use of lethal force constituted an arbitrary deprivation of the right to life under international human rights law and IHL, essentially because none of our victims were lawfully targeted. In particular, amongst the dead, there are 17 children, all of whom were killed in these strikes. These children were all under 15 and include a 3-month-old baby. Our second submission is that the use of force in this case violates the right to humane treatment of the strike survivors and the right to humane treatment of the relatives of these direct victims. So we said that the right to humane treatment of survivors was engaged because they had suffered significant physical and psychological harm as a direct result of the strikes themselves. This is all the more so in relation to the children, 14 of which survived the strikes. One of those children was found in his dead mother's arms. As for the next of kin, Inter-American jurisprudence states that they must be presumed to have also been victims of a violation of their right to humane treatment as a result of the pain and suffering caused by the unlawful killing of their relatives. Now, as with many drone strike claims, in our case, this harm is compounded by the fact that many of the family members were present when the direct victims were executed. Many of the family members are themselves strike survivors. Many of the family members found the mutilated bodies of their next of kin who were killed, and many of the family members have survived several years of impunity for these events. Additionally, the family members include 73 children who lost their parents as a result of these strikes. The disruption caused to their lives by the loss of these primary relationship has also had an adverse impact on their well-being, their development, and their mental health, falling within the protective scope of the right to humane treatment. Our third argument was that the right to humane treatment is also engaged by the constant hovering of drones and the strain caused by the anticipation of future attacks. So the evidence is that this is causing significant and irreversible psychological harm to the families and to the wider community in circumstances where access to mental health support is either non-existent or extremely limited. And this is not just our clients and Reprieve who say this. In 2013, forensic psychologist Peter Schapfeld traveled to Yemen to research the impact of drone strikes. He found that 92% of the people that he spoke to suffered from abnormal psychological conditions. 71% exhibited symptoms of PTSD, including anxiety and distress over the fear of being killed, sleep-related issues, and depression. Unsurprisingly, children are disproportionately affected. Having been exposed to violence and witnessed their parents and siblings being killed, many of these children are also exhibiting signs of PTSD, as well as other psychological disorders, including attachment disorders. Dr. Schapfeld described children as appearing, and I quote, as hollowed out shells of children who looked sullen and had lost their spark. So we say that what this body of evidence shows is that the sky in Yemen has become a source of terror, one that regularly inflicts violence without warning or reason on people who are already incredibly vulnerable to poverty and conflict. And we say that this constitutes a form of mental torture. Our fourth argument is that in light of the particularly egregious impact of these strikes on children, as I've touched upon, it is evident that there has been a wholesale failure by the United States to comply with its obligations under the American Declaration to afford special protection to children, in particular to take such measures as may be necessary to protect their right to life and their right to be free from torture. Fifthly, and finally, and I'll conclude here, it is our submission that the US has breached the rights of these victims and their next of kin to adequate redress. Despite acknowledging responsibility for at least 5 of the 7 strikes against our clients, the US has failed to conduct any meaningful investigation into the use of lethal force by its agents or to punish those responsible. Instead, where it has acknowledged responsibility, the US has merely asserted, without any evidence, that those killed were terrorists and thus targetable. And where it has acknowledged civilian deaths, the only reparation provided has been financial compensation. Consequently, 7 years on, a situation of total impunity prevails for this strike. This grave and ongoing denial of justice has caused profound anguish to the victims, and it is our hope that their rights to truth and to reparations will finally be vindicated before the Inter-American Commission. That concludes my remarks, and I can see Jen is now back online. So I'll stop there, and thank you very much for your kind attention.
Thank you so much, Julia. We really appreciate it. Okay, we're now going to move, hopefully, everyone cross their fingers, to talking to 2 of our next guests who are dialing in from Yemen. I'm next going to turn the floor over, technology permitting, to Ms. Ishraq Al-Makhtari, who is works for the National Commission for Investigation into Allegations of Violations of Human Rights in Yemen. Ms. Makhtari is a human rights lawyer and a member of the UN-mandated National Commission for Investigation into Allegations of Violations of Human Rights in Yemen. She serves as the official spokesperson of the Commission. Ms. Al-Makhtari has conducted in-depth investigations and produced reports on US drone strikes in Yemen, as well as a wide range of other human rights abuses, such as the political arrest and detention of women accused of sex work by the Houthis, forcible disappearances, torture, and other forms of extrajudicial killings. Prior to joining the Commission, Ms. Al-Maktari previously worked for Oxfam in the area of legal protection. She has extensive experience working with Yemeni civil society. Ishraq holds a master's degree in international humanitarian law. And now I'm going to turn it over. Ishraq, can you hear me? On to
شكرا
English.
بلاء، وشكرا للضيوف وللمؤسسات المشاركة بهذه الحلقة المهمة جدا، واللي جاية للأسف مع يعني مناسبة غير نقول مرحب بها، وهي ذكرى مرور 20 عام على محاربة الإرهاب، والذي للأسف يعني انعكس سلبا على حقوق الإنسان.
على العموم يعني الفكرة اللي بطرحها اليوم يعني أو المقدمة لهذا الموضوع يعني اخترت لها عنوان هي تحت مسمى الموت القادم بين السحب، ويعني هذه ربما العبارة هي جاءت بصيغة يعني عنوان لقصيدة قالها أحد المتضامنين مع الضحايا. ربما يعني الكل يعلم بأن اليمن هي الساحة الأولى يعني لتطرف محاربة الإرهاب، وربما يكون الأكثر بؤسا من أي دولة أخرى من حيث مكافحة الإرهاب وتأثيره على التمتع بكافة حقوق الإنسان. الأمر باعتقادي فيما يخص اليمن لا يحتاج لتقييم عميق، وإنما حتى بتقييم شكلي وأولي بيتضح بأن استراتيجية مكافحة الإرهاب فيما يتعلق باليمن وباستخدام طيران الدرونز يعني وجدت فيها أو سقطت في أعداد كثير من القتلى المعاقين. هناك الكل يعلم على الخسائر المادية والدمار في المساكن المزارع. باعتقادي أن كل هذه الحقائق الجلية والواضحة يعني تؤكد على غياب مبادئ حقوق الإنسان بهذه الاستراتيجيات التي اتبعت فيما يسمى مكافحة الإرهاب. وطبعا للأسف كان الطيران بدون طيار هو أكثر استخدام لهذا. العرض أو ربما الملاحظة اللي سوف أقدمها هو تأثير استخدام القوة حقيقة في عملية مكافحة الإرهاب، وتحديدا من خلال ضربات الطيران في اليمن. استمعت المداخلات الأولى أو العروض الأولى، وحقيقة يعني أغلبها ركزت أيضا على اليمن، ربما لأنه كما ذكرنا يعني في اليمن يعني ظهرت حقيقة التجاوزات، وظهرت حقيقة يعني التنصل للأسف عن مبادئ حقوق الإنسان، ولا سيما التجاوز الكبير في استخدام القوى. من الإحصائيات التي سوف أعرضها هي من وقائع عملية التوثيق والتحقيق في الوقائع التي عملت عليها اللجنة الوطنية للتحقيق. اتبعنا فيها آليات مختلفة، استطعنا الوصول إلى الضحايا وإلى للأسف إلى نتائج قطعية. يعني حددت فيها المسؤولية والقوانين والمواثيق المتعلقة بحقوق الإنسان التي لم يتم مراعاتها بل تم خرقها بشكل صارخ. وهناك أيضا يعني ملاحظات أخرى على مسألة توافق مكافحة الإرهاب مع المواثيق الدولية وفرص المساءلة للتقليل. وبداية أيضا نجد أن نؤكد أن استخدام القوة في اليمن كان بشكل مبكر، وتحديدا في نهاية العام 2002. منذ ذلك اللحظة أصبحت يعني الأجواء اليمنية مفتوحة لاستعراض الطيارات بدون طيار، وللأسف بموافقة وتعاون من الحكومة اليمنية. الكثافة هذا التحريق زادت، والقصف للأسف وسقوط المدني منذ 2009، وللأسف كان الأكثر يعني قسوة في 2009 هو حادثة المعجلة في محافظة أبيان التي سقط فيها 54 قتيل أغلبهم أطفال والنساء. بعد ذلك باتت عملية القصف الجوي تحرق مساحة كبيرة من محافظات البلاد الكبرى، إن لم تكن المساحة الأكبر باليمن، لأن المحافظات التي تستهدف هي تحديدا الجوف، مأرب، البيضاء، شابوة، أبين، وهي المحافظات الأكثر كثافة، وبالتالي مساحة اليمن أصبحت مساحة مفتوحة للطيران الدرونز. للأسف أيضا أن عملية الضغط والحشد المجتمعي بتغيير قناعات الولايات المتحدة والحكومة اليمنية بإيقاف الممارسة لم للأسف لكن للأسف أن الأمر صار الأقسى، هو أنه بعد انقلاب وسيطرة جماعة الحوثي على مساحة كبيرة من اليمن واستحواذها على كافة مؤسسات الدولة. فمسألة تصنيف الأشخاص تحت بند الإرهاب أصبح أيضا بيد عناصر الأمن القومي التابعة لجماعة الحوثي المسلحة، والتي هي أيضا تحمل فكر متطرف تجاه كل ما هو مخالف لعقيدتها ومنهجها وسياستها. أصبح بالتالي فالتي تحدد من تقوم بالطائرات الأمريكية بضربهم أيضا والجهات الداعمة للإرهاب هو أيضا جماعة الحوثي، وبالتالي هو مدخل للانتقام من الخصوم واستخدام ورقة الإرهاب في الحرب ضد اليمن للمناوئين للجماعة. وربما هو يعني نقطة نراها نحن مهمة أثناء عملية التحقيق. آثار ونتائج ضربات الطائرات بدون طيار على حقوق الإنسان في اليمن، للأسف أنه حتى هذه اللحظة لم تقدم السلطات اليمنية ولا أيضا السلطات الأمريكية أي جرد فعلي بعدد القتلى والضحايا بشكل عام. بالمقابل المجتمع المدني صحيح أنه قام بعدد من التقارير، لكن هي ليست تقارير إحصائية ولا يوجد فيها أرقام قطعية، يمكن لأسباب يعني مختلفة، من ضمنها أن هذه الحوادث يعني كما ذكروا في المداخلات التي سبقتني هي حدثت في مناطق أغلبها يعني نائية فقيرة بعيدة تنتشر في وسطهم الأمية، تدني وعي الحقوق، أيضا مسائل التبليغ، أيضا المجتمع المدني قدراته ضعيفة جدا لكي يستطيع عملية الرصد والتوثيق، إضافة إلى غياب حقيقة المشهد إعلاميا والخلط بين المدني الذي لا يجوز استخدام القوة المميتة يعني بحقه أو الشخص المستهدف ينتمي لفصيل متطرف مقاتل، وهذا قطعا لا يعني حرمان أيضا الأخير من حقه في الوصول إلى العدالة والمحاكمة القانونية. برغم طبعا صدور كما ذكرنا تقارير من المنظمات إلى أن يعني حدة وتيرة قصف الطيران زاد لا سيما مع اندلاع الحرب الداخلية في اليمن. لكن هذه التقارير ركزت بشكل أكبر على سرد بعض الوقائع وبعض الشهادات، لكن نحن في اللجنة الوطنية لتحقيق ادعاءات انتهاكات حقوق الإنسان يعني ربما هي تكاد تكون حاليا الجهة الوحيدة التي تقوم بعملية التحقيق بتلك الحوادث، لا سيما أن لا الحكومة ولا جهة أخرى قامت بفتح عمليات تحقيق بتلك الحوادث، ولهذا اللجنة أولت هذا النوع من الانتهاكات اهتماماتها وتركيزها منذ البداية، وضعتها ضمن أولويات أعمالها في التحقيق منذ بداية عملها في بداية 2016 بموجب القرار الجمهوري الملزم له أو المنشئ لها. حددت الولاية الزمانية والمكانية والمواضيعية بأن تقوم اللجنة بالتحقيق في انتهاكات حقوق الإنسان في عموم اليمن التي كتبت منذ العام 2011 وحتى اليوم، والتي ترتكب من كافة الأطراف التي بانتهاكات التي تمس قانون الدولة الإنساني وقانون حقوق الإنسان. يعني لهذا ربما كان هناك جهد كبير، وكثير من الوقائع التي ذكرت أو ذكرها الزميلات يعني مسبقا تم النزول إلى تلك المحافظات وتلك المناطق واللقاء بالشهود، تم تصوير أيضا الآثار المتبقية لتلك عمليات الضرب، أيضا يعني تم كتابة وتدوين كافة الآثار المباشرة والغير مباشرة للضحايا، وإعادة يعني قراءة وتحليل التقارير الطبية والتقارير الجنائية التي تحرك بعضها في تلك المحافظات. الشهود طبعا بالفعل يعني كان هناك يعني وضوح كبير جدا بأن هناك عدم التزام من الطيران الأمريكي بقواعد ومبادئ حقوق الإنسان وتجاوزه في استعمال القوى، وللأسف أن تلك الانتهاكات طالت الحق في الحياة والحق في السلامة الجسدية والعقلية إضافة تشويه وحالات تعذيب، وهي انتهاكات كلنا نعرف كحقوقيا أنها لا تسقط بالتقادم ولا يقبل فيها أي مبرر أو استثناء. اللجنة الوطنية انتهت من التحقيق في عدد 27 واقعة قصف طيران درونز حدثت بعد العام 2011، بمعنى أن الأحداث أو القصف الذي تم قبل 2011 لم يدخل ضمن ولاية اللجنة، وهذه الوقائع فقط التي استطاعت اللجنة من الانتهاء من التحقيق فيها ومقابلة ضحاياها. في هذه 27 واقعة التي حدثت في محافظات مأرب، البيضاء، شبوة، أبين، الجوف، هذه للأسف سقط فيها 142 ضحية، بين هؤلاء الضحية طبعا 112 قتيل و23 جريح. القتلى بينهم 8 نساء و24 طفل، والجرحى بينهم عشرات أطفال وامرأة. الوضع والأعداد من الضحايا هي التي كما ذكرنا استطاعت فيها اللجنة النزول إلى مناطق، مقابلة الشهود، الاستماع للضحايا الذين ما زالوا أحياء، وفي حالة يعني صعبة، والاستماع أيضا لذوي الضحايا. أيضا راجعت يعني اللجنة كما ذكرنا التقارير الطبية، وحاولت يعني أن تقوم بعملية وصف دقيق ومتكامل للمواقع التي تعرضت للقصف. وحقيقة يعني راعاها يعني كثير من يعني البؤس وكثير من الدمار النفسي الذي لاحظناه على الأسر، وبالذات ذوي الضحايا الذين فقدوا أبنائهم. أغلب للأسف من الذين توفوا من الكبار هم كانوا معيلين لتلك الأسر. هناك خراب كبير ودمار كبير جدا للممتلكات، للمنازل، أيضا للمزارع، للمناطق بشكل عام. اللجنة لتأكيد هذه المنهجية أدرجت في حقوق الإنسان، وبالذات الملف المتعلق في القتل خارج نطاق القانون، وهي الخشوم.
Just giving it a couple of seconds to see if she comes back online. Okay, I think what we'll do is we're going to go on now and hope Ishraq's connection comes back a little bit better, and thank Ishraq for her great comments. But move on now to Ahmed bin Ali Jabbar, and hopefully by the time we get to the Q&A, Ishraq's connection will be a bit better and she'll be able to participate and finish her comments in the Q&A. So Mr. Ahmed Ali Jabbar was on, for those of you who were more observant, he was on for a moment and has dropped off again. Connecting Zoom to Yemen poses its own set of challenges. We have, he's kindly sent through a video, so I'm going to just tell you a little bit about him and then play his video, and then we will move on to questions and answers, as I see there are several coming through. Mr. Ahmed Ali Jabbar is a communications engineer who lost his uncle Salam and his cousin Walid when they were killed in a US drone strike in 2012 in the remote village of Hashemir, Hadramut. Salam was an imam who encouraged his congregations to resist Al-Qaeda. He had preached against the armed group just days before he was killed. He left behind a wife and 8 children. Walid was the village's lone policeman. The family have been fighting for answers for their loved ones for almost a decade. Ahmed's uncle Faisal testified before US Congress and sought justice through the US courts in a case that was dismissed on political grounds. The family are now seeking to address Germany's role in US drone strikes, as the state provides satellite technology and support for the strikes from its base at in Ramstein. Ahmed is the lead claimant in a complaint filed at the German Constitutional Court. He continues to live with the terrifying sound of drones over his village. His story illustrates both the long-term impacts of drone strikes on whole communities and the failure of the international system to provide redress to victims of one of the most egregious human rights abuses. We will play his video right now.
يصادف شهر أغسطس مرور 20 عام على بدء الولايات المتحدة ما يسمى بالحرب على الإرهاب، وعقد من الزمان منذ أن قام أوباما بأول ضربة طائرة بدون طيار في اليمن. بعد هذا الوقت تغيرت حياتنا للأبد. بالنسبة لي كانت الولايات المتحدة تمثل حقوق دولة رائدة في تمثيل حقوق الإنسان والديمقراطيات، وكانت مكانا أردنا زيارته في يوم ما أو العيش فيه، وكذلك ينطبق على ألمانيا، دولة ألمانيا دولة رائدة في حقوق الإنسان. لكن الآن لا يمكن سماع أسماء تلك البلدان دون سماع أصوات الطائرات بدون طيار. كان عمي سالم إمام وكان يخطب ضد تنظيم القاعدة في المسجد، وابن عمي وليد كان شرطي الوحيد في القرية. كنا جالسين في مساء ذلك اليوم 12 أغسطس و12 أمام المسجد مع عمي سالم ومجموعة من الشباب، نتبادل أو نتجاذب أطراف الحديث عن هموم القرية. في لحظة اقترب ابن عمي وليد وبعض من أفراد القرية وقالوا في مجموعة هم ناس غرباء لا نعرفهم، لكن يشتبه في انتمائهم من تنظيم القاعدة أنهم يريدون الشيخ سالم. عندما عرفنا أنهم يريدون التحدث الشيخ سالم عرفنا أنهم من جماعة تنظيم القاعدة. في تلك اللحظة خفت وأخذت وسحبت يد عمي سالم باتجاه البيت في محاولة مني لإقناعه لأن لا يذهب، لكن شاء القدر وقرر سالم أن يخرج لمقابلتهم، وكذلك ابن عمي وليد بحكم أنه الشرطي الوحيد وقادر على حمايته في لو حصل أي حاجة. عندما عدت إلى البيت كنت عائدا إلى البيت، قبل الدخول إلى البيت سمعت صوت لا أعرف ما هو ذاك الصوت، لكن تبين لي بعض أنه الصاروخ الأول، كأنه شيء لا يوصف من الرعب ومن لا تعرف. سمعت أصوات الأطفال في كل البيوت المجاورة لي يصيحون ويبكون. صرت عائدا، رجعت وأنا عائدا إلى المسجد، إلى أمام المسجد باتجاه الموقع الغارة، فإذا بالصاروخ قبل وصولي، الصاروخ الأول، الصاروخ الثاني والثالث والرابع. كانت النيران مشتعلة في كل مكان والسماء سوداء. هذاك اليوم لا يمكن أن ننساه في تاريخ قريتنا أو تاريخ بلدتنا هذه، لا يمكن أن ينساه أي فرد عاش هذاك اليوم. ما زلنا نشعر بالاكتئاب في كل مرة نسمع فيها أصوات الطائرات بدون طيار. أنا لا أستطيع أن أنام لوحدي بالغرفة، وزوجتي تعاني من اضطرابات في النوم. أشعر بالخوف والقلق على مستقبل أطفالنا. سالم بعمر 6 سنوات، ويحيى الذي من أبناء 3، سالم بعمر 6 ويحيى بعمر 3، وانتظام بعمر 1.5 أو 2 سنين. إنهم حياتنا كلها، وهم يجلبون لنا الفخر والاعتزاز والفرح. في كل مرة يحلق صوت الطائرات بدون طيار في قريتنا نسرع لجلبهم ودخولهم إلى البيت. هم لا يفهمون سبب، لا يفهمون ذلك السبب، لا يفهمون ذلك السبب، ولا يمكن لنا أن نشرح لهم ذلك. إنهم فقط يشعرون بالخوف، إنهم فقط يشعرون بخوفنا عليه. عندما نسمع صوت أو يسيطر ذلك الصوت على قريتنا، على المنطقة، نجمعهم في غرفة واحدة ونشغل لهم التلفزيون أو الموسيقى بأعلى صوت، أو نضع لهم سماعات لكي لا يسمعوا صوت الطائرات. نحن نعيش في قلق ونعيش في خوف منذ ذلك اليوم. في وقت الضربة كان هناك، أو في أماكن مجاورة للضربة كان هناك أطفال يلعبون في القرية على بعد أمتار من مكان الضربة، وهم حتى الآن وبعد هذه السنوات الطويلة من الدعم النفسي ما زالوا متأثرين ويعانون من مشاكل في النطق، عمر وإيماس وكثير من الأطفال، ومشاكل في التبول اللا إرادي. أطفالنا يستحقون أفضل بكثير من هذا. أريد أطفالي أن يكونوا قادرين على ممارسة حياتهم بشكل طبيعي، أن يتحركوا دون خوف. يريدهم أن يكونوا قادرين على مشاهدة الألعاب النارية. افتقدت سالم بكثرة بشدة، افتقدت روحه وضحكته، لكن كان خفيف الظل ويحب الحياة ومحبوب في كل مكان يذهب إليه، ينشر الفرحة لمن حوله. كان مدرسا وإماما متهم بجميع قضايا المجتمع. ووليد كان لطيفا ومليا بالحياة وكذلك كان شرطيا في القرية وشاب مفعم بالحياة. لم نكن فقط أبناء عمومة، بل كنا أصدقاء طفولة، ذهبنا إلى المدرسة ونشأنا معا. حتى هذه اللحظة لم نتلقى أي اعتذار من الولايات المتحدة الأمريكية. وبعد أن أصبح الرئيس بايدن رئيسا قال أنه سيتوقف هذه الضربات، ولكن في الأشهر الماضية سمعنا من هذا العام وفي شهر فبراير بالضبط سمعنا تحليق كبير للطائرات الدرونز فوق قريتنا وفي سماء منطقتنا بأسرها. نحن نواصل كفاحنا من أجل العدالة لسالم ووليد، بينما تستمر الطائرات بدون طيار في ترويعنا حلفاء أمريكا في أوروبا برضه هم أيضا يتقاسمون هذا الألم الذي سببوه لنا. من حقنا في حياة سعيدة، ومن حقنا نريد أن نحمي أرواح عائلاتنا، ونريد المسؤول في أو أرواح عائلتنا أو المسؤولية عن مقتل سالم ووليد لأنهم يقدمون. وكذلك حلفائنا في أوروبا هم مسؤولين لأنهم يقدمون المساعدة لتنفيذ ضربات الطائرات بدون طيار ويحرموننا الحق من الحياة. يا ريت أن يسمع صوتي جميع العالم، أن يسمعه جميع العالم. نريد أن نعيش بسلام بسلام بسلام، لا نريد أكثر من ذلك، بعيدا عن أصوات الطائرات وبعيدا عن المشاكل فيما عشناه في ذلك اليوم. إنه يوم لا يمكن أن ننساه في قرية. دمتم بخير.
We're now going to move on. We've got a few questions in the Q&A box, but I think I'm going to take a little bit of facilitator's privilege and ask the first one before moving on to those. And I just want to connect a little bit of what I think all of our panelists discussed in various iterations, which was this has been going on for a long time now. Concerns have been raised, as Professor Neeline pointed out. Her mandate was dealing with the issue back in 2013. But what struck me is that all of our panelists talked to some degree about the broader impacts of the strikes. Jelia, you spoke about the impact on those who witnessed it in the community. Shahzad, you talked about the families who've been fighting for justice for a long time now. And I wonder, my question to the panelists is one of the lessons we need to learn from the last 20 years that the damage is not just a body count when it comes to drone strikes, but that the damage and the harm that we should be calculating is much broader than that. I think I may actually turn that over to Jelia first, and then perhaps Adriana, you could weigh in from the mandate's perspective.
Thank you, Jen. I mean, I think that's absolutely right. I think we have to look at these things.
I think, Jelia, I think we can't hear you.
Oh, really? I'm not on mute. Can you hear me now?
We can hear you now.
Okay, all right. So no, what I was saying is that I think that is absolutely right. And I think if we focus exclusively on the body count, and if we characterize this only, and I, you know, obviously it's very serious, but if we only look at this from the prism of arbitrary deprivation of life, I think we lose sight of all the other ways in which drone strikes violate people's human rights and affect targeted communities. And I think as lawyers working on building and presenting these cases, it's important to capture all of the ways in which drones affect fundamental rights to give our clients the best shot at access to remedies. So I think it's important definitely to try and have that broader focus, and then also within that to not overlook those communities that accountability processes historically tend to overlook. And in this particular instance, I would sort of emphasize children again.
Adriana, I don't know if you want to add to it from the mandate's position.
Certainly, I think that Jelia's presentation was an excellent illustration of the fact that too often we just focus on the right to life violations, when in fact there are a much wider set of violations, often at a population level, related to the terror of those populations. And I think certainly whenever we think about or talk about the current absence of regulation, the lacunas in which this is occurring, we need to make sure that our framing of the appropriate regulatory frameworks takes account of a wider set of violations.
Okay, I don't know if anyone else from the panel wants to add. think we have Ishraq back. Ishraq, if you do, just Barak can help translate. His Excellency, Mr. Shahzad Akbar, do you want to weigh in on this question of whether one of the lessons we need to learn for the past 20 years is that actually the harm was much broader than a body count?
Yes, I think the impact is much larger. And when we're looking at the impact of use of drones, we also have to see, we have to balance it with what is, if we are using drones in a non-profit manner, we also have to see what benefit we are going to get or getting out of it. I think, as has been said earlier, it's a big gray area when it comes to legality of drones, because I don't think that you can declare the whole use of drones en masse legal or en masse illegal. Every strike has to be taken on its own merit. But at the same time, in terms of the benefit of drones, if drones is considered to be the best weapon against terrorism, the only theater of war or non-war we have seen is the last 20 years of war in Afghanistan. And I think the results are right in front of us. How much it has been successful, it's a still big question mark. Now, when it comes to the impact of drone, it's much wider. There are a number of cases, as you are personally witnessed, that we have seen ourselves. It actually creates more militants rather than actually eliminating. So the impact of drone is not just on human life, but also it's not really serving the very purpose that it is being used for. So therefore, and it's not, I think we will be confusing the debate if we're just focusing on the weapon. I think for me personally, it is the use of lethal force and the circumstances that it is used in. And that is the key question. And if we continue to use that, it's not going to get any benefit. And also in the communities that it has been used, for example, Pakistan, Yemen, or Afghanistan, it has not borne any results for the very purpose that it has been used. However, it has, I think, divided the communities more. It has created a huge impact. There has been less belief of people in the due processes. The divide between West and the developing countries has widened. So I think the impact is much greater, and it's not just the body count.
Okay, thank you. I'm going to move on unless there's anyone else on the panel who wants to weigh in. I'll give a moment just in case Ishraq does. Okay. The first question we've got up in the Q&A is from Professor Mary Ellen O'Connell, who's written a lot on this subject. Her question is, UN Special Rapporteur Asma Jahangir of Pakistan concluded in 2003 that in November 2002, US drone strike in Yemen, killing 6, was an extrajudicial killing. She applied human rights law. She did not accept a justification of self-defense under Article 51 of the UN Charter or the US claim to be involved in worldwide hostilities justifying killings under IHL. After years of study, I conclude Ms. Jahangir's statement of the applicable law remains accurate. I also conclude that even within armed conflict hostilities, targeted killing violates IHL. What steps can be taken for these positions to be adopted again by the UN and used to assess drone attacks? I think I'm going to come first to you, Adriana, unless His Excellency, Mr. Shahzad Akbar has come off mute. Do you want to go first?
Just very briefly, just comment on this. And I think Professor Mario Collin was one of the persons I started quoting from very beginning of my work as well. And I think I totally agree with her analysis on the legality or the whole drone strike scenario. In terms of, yes, there always be, and I think that the question, the example is of the recent Afghan drone strike as well. There will always be questions, and there will be always applicability of international human rights law. Now, the issue is, how do we assess it? And first of all, I think what I spoke earlier the use of drones by intelligence agency is the problematic area, because it's also the actors who are using drones. Because if it's a body which is under certain established norms, international law, where Geneva Convention applies, there is a different set of transparency for that. And there's usage, for example, within Pakistan, as we saw, and in some cases in Yemen as well, the use is within intelligence agency. It is an unrecognized, no one is really taking ownership. There is no ownership at all. So when there was a, Datta Khel strike, when Jirga was hit and all the tribal elders were killed, there was abundance of evidence, all civilians, tribal elders killed, but there is no ownership, there is no recognition. And I think, first of all, what is most important to use or do is that, first of all, we have to determine if it is to be used, if the use is to be legal, who actually cannot use it. And in this particular case, the intelligence agencies, can they actually use drones, lethal force? So I think that would be the beginning of the whole thing.
Adriana, would you like to weigh in from the mandates perspective?
Yeah, thank you very much. And thank you for the excellent question. I was fortunate enough to have sight of Mary Ellen or Professor O'Connor's paper before today's event. And it's been extremely useful to the mandates thinking to date. I think Fionnuala, in her earlier remarks today, set out the historic position of the mandate on this issue. It has been some time since the mandate's position has been updated, and we expect to publish something more fulsome over the next period. But for now, I will take the question on notice. I think you're muted, Jen.
Sorry, Jelia, are you still there? I think she might have had to, could you take one quick question?
If only I can answer it in about 30 seconds, because I've got another meeting about to start.
I think you're muted, maybe.
No, I don't think so. Can you hear me?
Yeah, now.
Okay. Yeah, I do have to head to another meeting. So if it's a short question, sure, because I've got about 2 minutes.
Okay, so let me skip ahead. On the examples of the drone strikes and the raid you gave, could the US legally justify them as necessary counterterrorism operations with unavoidable collateral damage, i.e. that the civilian life, the military gain outweighed the civilian loss?
No. No, I mean, very briefly, the first strike was governed by human rights law only, because at the time, the US wasn't a party to an armed conflict. And under that regime, the requirements of necessity and proportionality were just clearly not met by this strike, which ended up killing a sizable group of people as they were traveling to a wedding procession. And remember that under the human rights regime, even if you are purporting to target, ACAP members, for instance, which is what the US often says, you need to be able to justify targeting everybody else that's been killed, which they're not able to do because they recognize that a lot of family members were killed. In relation to the other strikes, one of them was a ground raid. So that's quite material because it was, around 12 highly trained US Navy SEALs conducting basically door-to-door searches and killing everybody that they found, carrying small arms. So there isn't really an argument of collateral damage. There's a clear violation of the principle of distinction. In relation to the other strikes, which were drone strikes, there's simply no evidence that the individuals who were targeted were members of ACAP, as the US has alleged, but without producing any evidence to that effect. And so we say there's been a wholesale failure to abide by the principle of distinction. So that's a brief summary. I'm so sorry, I'm going to have to go. Thank you so much. Bye.
Thank you, Jelia, very much. Okay, I think that was a very specific question. The next question I'm going to take and go to His Excellency, Mr. Shahzad Akbar again, mainly because the question is, are there international legal frameworks that may be based on criminalizing the use of drones? And I know you did a lot of the work you did in Pakistan was about arguing these strikes are crimes under domestic Pakistani law. And I wonder if you want to talk about that a little bit.
Yes, I think the issue, one of the initial problem that we had when we started the drone litigation on behalf of civilian victims of drone strikes, absence of any international forum or mechanism where the very action of usage of drone could be termed criminal and action could be taken against them. Therefore, we used the domestic legislation because Pakistan was not party to the armed conflict. However, US has its own interpretation, but Pakistani civilians killed inside Pakistan in a drone strike, according to Pakistani domestic law, amounted to a criminal offense because it's basically plain and simple homicide. And upon that, we pursued that claim and we brought criminal charges against certain officials, and we were successful in actually getting to the jurisdiction point where the courts actually assumed jurisdiction and said, yes, it is actually homicide. A citizen has been killed by use of this weapon. So the case is actually, we had that kind of remedy available. I mean, there's another challenge how to execute those warrants internationally in another jurisdiction, but at least the very basis of that argument was won.
Thank you very much. Ishraq has also asked me to read out, because of the technical difficulties, she's going to stay on mute, but she's sent through her answer to that question, which is that it's the duty of states, one, to stop committing extrajudicial killings and instead follow the judicial procedures guaranteed in international human rights covenants, which are also in line with the rights and procedures in the national laws of the states parties to combating terrorism, specifically ensuring fair trials for the accused. Two, compensating the victims and their families and redressing them in a fair and appropriate manner for all the violations they have suffered: murder, mutilation, destruction of property, stigma, environmental damage, one that's often not talked about as much with drone strikes, loss of breadwinner, fear and panic, and forced displacement. The international community, three, has taken a position on countries that export drone technology and are used to kill Yemenis. Using this method without being subject to the law is a violation of international laws and charters, and just as countries and the international community have taken anti-Semitism as a pivotal and rejected action, there must be a tendency to consider the use of this weapon and the method of killing civilians as a racist-based hostility against citizens in these countries, such as Yemen, whose residents are living in fear of the drones, and all strikes against civilians are extrajudicial killing without any legal provisions. And four, she wanted to add that activating the role of the special rapporteur on the promotion and protection of human rights is important. I think we have no more questions. If there are no, there is another question. Would recognition of a specific human right to live without physical or psychological threat from above help to enhance protection against drones? Adriana, can I come to you first for this one?
Certainly. Just to understand the question, is the suggestion that we set out a new norm?
I believe it is. I can, let me see if I can find Nick on the list. If Nick, if you want to come on, and I've just allowed you to talk if you'd like to explain a little bit more.
Thank you very much indeed. I've lost visual contact with you, but I hope you can hear me. Yeah, I'm involved in a project with another colleague called the Airspace Tribunal. Oh, sorry, can you hear me?
Okay, for some reason, it's not working, Nick. So
shall I put it in the chat?
If you do come on, feel free to jump in. Oh, I'm being told everyone else can hear. So for some reason, just I can't hear. So go ahead.
Okay, thank you very much indeed. No, I'm involved in a project called the Airspace Tribunal. It's a people's tribunal. We've been holding hearings around the world, gathering evidence from experts and people with rich and diverse lived experience, particularly of living under drones. And a lot of the evidence we're hearing is about the psychological effect, the long-term intergenerational psychological effect of drones. And the particular purpose of the tribunal is to examine the case for and against a proposed new human right, a specific human right, to live without physical or psychological threat from above. So yeah, we're talking about a new norm, recognizing that you could perhaps carve such a right out of existing rights or create such a right through dynamic interpretation of existing rights. But we're arguing that this is so fundamental that a specific norm, new norm, needs to be recognized. And what we plan to do once this project is completed is document it all and present the dossier to the UN and other international bodies with what we hope will be a compelling people-focused proposal.
So just to, I'm going to very quickly just summarize what Nick was saying, because I think there was a little bit of an issue with Nick being off the translation button. So those of you that were on English might not have heard. But they are working on a tribunal to establish potentially a new norm around the right to live without threat from above. And would this help move things forward? And they've heard a lot of evidence about just some of the intergenerational effects, this hovering from above and the kind of psychological threat from above can cause on communities. Adriana, would you like to weigh in?
I think the point is an interesting and good one, and one obviously that I think that was picked up in Jelia's comments today. And I think conceiving of this issue as one that is wider than, as has already been said, a body count or simply an issue of right to life, it is important. I think the intergenerational trauma point is also important. And I think if we think about it in terms of, for instance, the Conventions on the Right of the Child, and the way that that type of trauma might affect a child's right to education and other associated rights, I think that is possibly a way to get at the same issue of intergenerational trauma and of psychological harm. On the question of whether or not we need a new norm to specifically address this issue, as I said, the mandate is in the position currently of developing its position, and I think without more, I won't comment specifically on Nick's proposal, but I think the underlying idea or issue behind it about capturing more than simply the effect of drones on the right to life is an important and a very good one.
Would anyone else on the panel like to weigh in? Give you a second. I think Ishraq has lost her connection. Okay. If there are no other questions, I've just been reminded of the classic Zoom failure of being on mute. I want to thank everyone for coming, for hanging in with us there through the technical difficulties of connecting with Yemen. And thank you again to the panelists for their wonderful insights into where we take this debate, what we've learned from the past 20 years, and and how we move this debate forward as we go into the next decade to make sure that lessons have been learned. So thank you everyone for attending. We very much appreciate it. And thank you to our panelists.
Thank you very much, Jen.